Really quickly here, also got to make sure that the final income taxes for the person who passed away get taken care of. We talked about estate taxes, whether, those may or may not be on the table for the estate, depending on the overall value of the estate. And then to the fun part, distributions. At some point, all of these assets, whatever's left over after payment of expenses and taxes, need to be transferred over to the people who are entitled to receive them, who are the beneficiaries, right? Or who are the heirs. Heirs are people who are entitled to receive assets if there was not a will. Beneficiaries is a term that I use for people who are entitled to receive those assets if there was a will, right? But sooner than, hopefully sooner than later. And I realize, Ruth, I never answered your question. If it's sometime, if you are really lucky, you can have everything wrapped up in 6 months, but I wouldn't count on it. And the reason for that is simply because there's that process to ferret out creditors and deal with them. That's going to take some time. It can also take some time to get the inventory together, to deal with taxes. So I would say plan on a year or more. If there's estate taxes involved, you're probably looking at a couple years, just because you want to get releases from the taxing agencies that the estate taxes have been paid. Now, please, Debbie.
Okay, so what happens to your personal property, jewelry and all that? Does that only administrator distribute that? Or does that have to go probate years before they get,
Yeah, right. So again, it depends on what the will says, if there's a will, about tangible personal property items, because different wills may say different things, right? But let's just say that the will says I leave my tangible personal property items to my children, and there are 3 kids, right? And maybe that's all the will says. So there's kind of a presumption that it's going to be an equal distribution. The personal representative is basically going to be kind of the referee to determine how all of that gets distributed out. Now, with the tangible personal property items, from my view, we want to try to deal with that as soon as possible, because that stuff is annoying.
So it doesn't have to be listed in categories for probate, the administrator.
So it's still subject to probate, right? It falls under the authority of the personal representative, but they have the authority now to deal with it and to do with it what needs to happen, because they've got that during probate. During probate. So you have, can I take you as the example here? Okay. 2 girls, okay. Married? Widow, okay. So your will says I leave all of my tangible personal property to my 2 daughters, okay? And you put daughter 1 in charge of your estate. Daughter 1's going to take your will, probate it with the court. It's going to get authorized, going to get those letters testamentary. Ish. Depends on the time of year as well. If you're trying to probate an estate around Thanksgiving or Christmas, plan for more time. But so she's going to get those letters testamentary issued. Once she has those in hand, that means she has authority over all the tangible personal property to then, okay, what did mom's will say? This goes to my sister and me equally. All right, let's talk. How do we want to divide this up? And because people overemphasize the value of the personal property because of all the sentiment that's involved with it, it's usually stuff that's not going to affect the bottom line of the estate. So you want to get that out as soon as you can, right? And so for that reason, yeah, one of the things I wanted to talk about is partial distributions. So it does not have to be the case that the person in charge of the estate has to wait until the very end of probate before anything at all gets transferred. They can be making partial distributions along the way, as long as they feel comfortable enough that there's enough left over, or that they have enough of a cushion for any expenses that may come up during the process. So it's been frequently the case that we've made partial distributions just to help the beneficiaries feel like, hey, you're getting something, we're working on this. Now we still have these other things we got to take care of, but here's a portion of your inheritance now. We'll get you more later as we get more stuff sorted out.
And then they access to the bank accounts that, are TOD.
If you have TOD accounts, again, that's not probate. That's in the non-probate side of things, right? So they would be able to go and collect those right away. So it has a death certificate. Correct. Death certificate and proof of identity is really Those are your keys for those kinds of accounts. Yeah. So, sorry, Lisa, did you have a hand up? Okay. Just like, oh, I can't wait to get out of here. So now once you finally got everything wrapped up, right? Taxes have been paid, expenses have been covered and paid. You've figured out the debts and you've distributed the property to the beneficiaries. Then you have to formally close the probate. So usually that's done through a fairly simple process called a declaration of completion. And I've provided a sample in the materials that you can look at to see. You're going to list out different fees that get paid to the lawyers, the accountants, the appraisers, and if the personal representative is going to take a fee for his or her service for administering the estate, they can do that typically. But that's at that point in time, that's a happy day because you can formally close the probate and say, okay, I think we're done with this, right? Now, that's not to say probates can't be reopened. That does happen from time to time because things get missed. But again, I would plan on, as an average, about a year. But again, there can be those partial distributions along the way if the personal representative feels comfortable that, hey, I've got enough to deal with the pending liabilities. So yeah, why don't I make some partial distributions to beneficiaries so they can have some now? You don't have to wait till the very end.
If you sell the house, then you can.
Uh-huh.
Sell the house, where does that money go?
That money is initially going to go into a bank account for the estate, right? And then because the amount there could be significantly large, if it's the sale of real estate, especially if there weren't, if the mortgage had already been paid off, you're going to want, the personal representative is going to want to break that up to stay within the FDIC or NCUA limits, insurance limits. So if you're getting like $500,000 in proceeds, you want to break that up so you're only keeping a portion of that in the estate bank account. And then the rest of it you want to put into estate investment accounts that are conservatively invested until those assets get distributed to the beneficiaries later on.
So you don't get taxed on it?
Well, there won't be income tax necessarily to the beneficiaries when they receive it, but there could be some income tax to the estate. So if you're conservatively investing the estate assets, they could be generating some income between the time that they're invested and the time they get distributed. And so somebody does have to pick up that income tax for the estate. Oftentimes that gets passed along to the beneficiaries so that the estate doesn't have to pay it at higher rates. So again, it's generally there's not income tax to the beneficiaries themselves, but they can kind of pick up some of the income tax liability to the estate if there's some there. Now, sometimes, again, depending on the way things play out, maybe Debbie, in your example, the house gets sold, but there are other assets as well that are going to be available to pay any debts or expenses. And the personal representative decides, well, you know what, let's just, in your situation for your two daughters, personal representative, your oldest, or let's say your oldest daughter's in charge. Is she going to be the one in charge? Okay, the younger one then. So the younger daughter says, hey, we've got all these proceeds. We got other assets that are going to be more than enough to take care of other stuff. Let's just go ahead and split this now. And so rather than putting it into an investment account where it has that possibility to make income for the estate, your youngest daughter could make that partial distribution, split it in half, send half to her sister, income tax free to them. There hasn't been enough time for those assets to generate income for the estate. And then whatever they do with it is up to them at that point in time. You want a lawyer, you want a CPA, and you probably want an investment advisor as well, or financial advisor. That's kind of your team.
I've been using different terms, administrative, personal representative. In my mind, it was always an executive. Are those the same? Great
question. So umbrella term in Washington is personal representative. That's your umbrella term. That can apply to both an executor and an administrator. Executor is somebody who's in charge when there's a will. Administrator is the person who's in charge when there's not a will. So executor, there's a will. Administrator, there's not a will. Personal representative could be either or.
Okay. And my other question is, how do you determine how much that person gets paid to do all that work?
I provide some tracking sheets for my clients who are serving as executors or administrators, so that they can write down They can document, okay, on this date, I did this thing for the estate and it took me about this much time. So it's basically a timesheet that they want to keep. And then it's really fuzzy. It's reasonable compensation. So the time ultimately, this is where it gets really funny. Ultimately, the personal representative determines that. So it's you kind of decide your own hourly rate for that within the check of maybe somebody's going to object to that. Maybe if you're charging, if you're charging what the lawyers are charging per hour for the work that you're doing as a personal representative, that's probably going to be a problem. Sorry, it's just the way it is. And you might have beneficiaries that object to that, right? In the end, when you're filing the paperwork to close the probate, you have to list out if the personal representative took a fee, what the fee was. It just has to be the final number. But a beneficiary has the right at that point to look at it and go, I want a fuller accounting. I want to see where that number is coming from. So you have to be careful with that, right? So I would say that I see for lay persons who are serving as personal representatives, I see hourly rates that range between $20 to $50 an hour. $20 to $50 an hour.
Can you just establish a dollar amount that is titled?
Like and put it in your will.
Yeah, like $8,000.
You can. Yeah, if you wanted to drill down and be more specific in your will about what the personal representative's compensation is going to be, you could do that. I would offer a couple cautions. Number one, if you do that, you may be giving them a disincentive to take on the job because they don't know what all is going to be involved. And if you're saying your compensation is going to be a flat fee of $5,000, again, what are they getting themselves into? Maybe there's $20,000 of work there and they're getting shorted. If you're providing them with an hourly rate, again, that's likely going to reflect going rates at the time that you make your will. But, if it's 20, 30 years down the road, they're going to be working for a much reduced rate. So you can do it. You can do it. You just have to keep those things in mind.
Does the declaration of completion go to the court and they actually approve?
They do. Mm-hmm. Well, it gets filed with the court and then it's presumed to be approved by the court. The court doesn't actually sign it off on it, but the court is presumed to accept it if nobody objects within the time frame allotted. It's about a 30-day period once it gets filed and notice has been given to the beneficiaries. If nobody says boo, then we're all good, right? Alternatively, if everybody's playing very nicely with one another, you can have all the beneficiaries sign a statement saying, hey, I'm waiving my right to this period of time to object. We're all good to go here. If everybody signs those and files them with the declaration of completion, you're done at that point in time. So that's my preference because that means everybody is getting along and things have gone more or less according to plan and we can just be done with the whole thing and we're not worried about any final fights breaking out among people that are involved with the estate. Anyway, we've run over. I'm so sorry. There are toward the end of the materials before you get to the samples, I try to address some of those initial questions that I posed about, what are, is the government going to get everything? The answer generally is no, don't stop worrying about that, right? And there's some other follow-up answers I give to those questions as well, which you can look at there. But I think I'll go ahead and end that there for now. If there are others that have questions, I know there were a couple that I was going to talk to after the meeting here. Let's chat a little bit more. But thank you all for coming. I hope this was helpful.
Thank you. More available copies of today's handout. If you ask for last handouts,
My face kept